Thank you for joining us today. I've been a public defender for 24 years. Chris has been a public defender for a really long time. And as a public defender, I've had a lot of time begging judges to let my clients out of jail. I think all of us have had that experience. It has been a very long time that knowledge of how the bond bail system in this country works or has worked was not very good. In my experience as a public defender, I don't have a lot of clients that look like that. My clients are poor and homeless and drug addicted and mentally ill and also presumed to be innocent. Unfortunately, historically, they didn't get out of custody. The judges would throw cash bonds at them and my people would be stuck. And one of the byproducts of that fact for years and years and years was that we had people that were forced to take deals. It was the only way to get out of jail. They had families and children who didn't have a parent. They had jobs they lost, and my clients desperately couldn't lose their jobs. And so all too often, $500 cash would force my clients to plead guilty. And I've spent way too much of my career begging people not to take a deal that was a terrible deal, but the bond forced them. Fortunately, that's changing. So, talking about bail, this is from the Colorado bond statute. It sort of sets forth the purposes of bail. I think we all know that the sort of meta purpose or first purpose of bail is that people shouldn't be punished in this country just because of an accusation. In my career, historically, they were. But that's why we're supposed to be having bail in cases. Our statute sets forth specific things that bail should accomplish. Obviously, bail is intended to ensure people appear in court, and then another consideration is protecting the safety of the community. Protecting the safety of the community is obviously the hook that judges use all too often, I think. Historically in Colorado, and I think most places, the very last part of this statute, taking into consideration individuals' financial circumstances, was something that the courts didn't consider. And that's why public defender clients and frankly everyone in the defense bar's clients are all too often in custody. This language was inserted into our statute in 2013, and it has been a monumental sea change in what it allows us to argue from the courts. Where that change came from really comes out of a lot of scientific research that started. A lot of it started in the 90s when various courts and agencies started looking at implementing evidence-based decision-making processes into the judicial system. For whatever reason, the courts have been way behind other professional fields in the implementation of EBDM work, but that has started to come around and has really come around, I would say, in the last 10 years or so. One of the areas that's been looked at a lot is bonds, and that's one of the things we're going to talk about, hopefully give you some ideas you can use to work with your courts. So, what does the research tell us about the purposes of bail? If you get nothing else out of my part of this lecture, this slide right here is the cornerstone of how you want to structure your conversations with your judges and with your DAs, because these 3 points really summarize everything that justifies getting away from cash bonds, and more importantly than that, it really is indisputable at this point. The research is clear. Research is always ongoing. Scientists continue to work on this, but there is, to the best of my knowledge, there is nothing out there saying that cash bonds are a great way to ensure any of the purposes of bail that we look at. So probably, in my opinion, the most important thing, there is tons of research out there that money doesn't make people come to court, money doesn't make people not commit new offenses in any significant higher rate than other kinds of bonds. What makes a giant difference is doing risk assessments, and you can tailor your bonds specifically to an individual's risk assessment and know with almost certainty the likelihood of them either reoffending or picking up a new case. Once a judge grasps that concept, you are well on your way to getting a whole lot more PR bonds. And again, the science is clear. So this is something that you are going to win the argument if you can just get the enemy, whether that's a DA or a court, to read the research. The other thing that is important, in my personal experience, I had a great deal of luck with my DA in pushing the idea that people that are locked up pre-trial, we are increasing the chances of them committing new offenses. So if the goal, and DAs will tell you, the goal is to make sure people don't commit new offenses. Well, if that's your goal, getting people out of jail is a great way to accomplish that goal. That is so counterintuitive to the thought process of DAs that you have to repeat that concept to them over and over and over with the literature in front of you. And eventually, even my DA got it through his head, so I think your DAs will too. Eventually, after a long time. So talking a little bit more about some of those specific points. Money does not ensure return. There's tons of scientific literature out there. You can find this stuff on the intranet. There are a host of resources out there for you. I put up the picture for the Pretrial Justice Institute. Pretrial Justice Institute did a bunch of work in Colorado validating the CPAT, which we're going to talk about more in a minute. But their website has the validation studies. Their website has all kinds of links to other sources. We'll talk about some other places you can look. But this principle is absolutely undisputed in the literature. Money doesn't ensure people come back to court at any significant higher rate than PR bonds with some kind of pretrial conditions, perhaps, especially when they're used in the context of a risk assessment. So if you are starting the process of convincing judges and starting the process of convincing DAs, start by educating yourself. I would encourage you to look at PJI, but there's also all kinds of other agencies out there, including the DOJ's website. So start by looking at these sources, because historically public defenders' arguments have often boiled down to, judge let him out of jail, he gets it, he's not going to commit a new offense, and he promised me he's going to show up. If you're like me, that argument didn't win very often. It is amazing to go in there and argue bond with a scientific study in your hand. It makes a difference, and it's out there for you. So, we talked about the idea that you have to use risk assessments when you are making the argument, and here is why. This is from the validation study that was done by the PJI, working on Colorado's pretrial assessment tool, henceforth known as the CPAT, because that's shorter. These numbers have been scientifically validated, and they are monumentally significant, in my experience at least, with courts, and they are significant, in my experience, with DAs. When you do the CPAT, you're going to get a risk category. So that's the left-hand column. You come up with one of 4 different risk categories. Based upon your risk category, we know that 91% of the time you're not reoffending. We know that 95% of the time you're going to make it to court. We also know, at least in this validation study, that 20% of the people that are arrested on a new offense and in jail for their first bond setting are going to be a risk score of 1. I would suggest to you that between risk 1 and risk 2, 69% of the people that are arrested should be out of jail. I just think it's clear. The public safety rate, court appearance rate, very high for those individuals. 69% of the people do not belong in jail. And if we're not doing PR bonds and we're doing cash bonds, a huge component of those people are going to be stuck in jail. In a minute, we'll show you some numbers from Grand Junction, where I'm from, that shows how the PR bond rates changed. And you'll see that in many counties, before they start looking at the data here, PR bond rates are very low. And it is absolutely clear that a huge majority of our clients should be out of custody. CPAT 3s, I think, and I think most public defenders and defense people believe should also be out on PR bonds, perhaps with some conditions to ensure that those people get some help to stay in compliance. But I think there's great arguments for all the CPAT 3s to be out. Your CPAT 4s, at least in my experience, in Mesa County, we don't get a lot of PR bonds on CPAT 4s. You get a lot of PR bonds on CPAT 4s?
Every once in a while on drug cases,
Really?
we will. They fail, unfortunately, fairly often. But on drug cases, on CPAT 4s, we'll get it with supervision.
But that a lot of them fail is absolutely what we'd expect, right? Our public safety rates, our court appearance rates are much lower. I think with some conditions, a lot of them are also successful. So you got arguments on your CPAT 4s, but we're not here to tell you you're going to get PR bonds for your attempted murder guy who's out on probation violations. You're not going to get those PR bonds. And that doesn't mean, obviously, you shouldn't try, but this stuff is really, really focused on all of those people, and again, most people who shouldn't be in jail in the first place. And this is where you can really move the ball forward. Okay, so this slide was pulled out of after Colorado changed their bond statutes in 2013. Part of the change required data collection by the courts, and they published that. You can find it online. I picked the 21st Judicial District because that's mine, and I'm familiar with these numbers. But this is court data that they collected following our bond change. Our bond change is what specifically told the courts you had to consider a person's financial circumstances. I've been in Grand Junction for a long time, and so I know these years that they are looking at are pretty significant. Prior to 2011, Grand Junction just had a bond schedule, probably like everybody else did back then. And Grand Junction's bond schedule had absolutely no basis in reality. There was no reason for it. Even to this day, I can tell you a Class 5 felony was a bond schedule of $3,000. A Class 4 felony was a bond schedule of $5,000. Nobody ever knew why. That's just the way it was. It was around 2010, 2011 in Mesa County that the court and the DA and the Public Defender's Office started talking about some evidence-based decision-making, started actually asking, why do we have these numbers on our bond schedule? But in 2012 was really when we started seriously pushing the idea that more people could be out of custody. And you can see how our PR bonds, PRs in green, you can see how our PR bonds started climbing up. And then in 2013, with the new bond schedule, our PR bonds skyrocketed. We've been pushing the PR bonds real hard. We've got a lot of buy-in. Let me qualify that. We have buy-in, not a lot, from the courts. And so our PR bonds have gone up a whole lot, which is amazing. That means human beings are out of cages. And that's what we do. So that part's phenomenal. Equally phenomenal, I suspect, or I believe at least, is that if you look over in the bottom corner of this slide, so in the bottom right corner, it talks about our failure to appears and the personal recognizance. The green shows the number of people that have not failed to appear. And the number of PR bonds that we get the courts to give out has gone up a huge amount, and our FTA rates have stayed the same. This is clear evidence, and I submit indisputable evidence, that too many people were stuck in jail that should have been getting PR bonds. When this data came out, the chief judge in Mesa County, who, bless his heart, struggles with these concepts sometimes, the chief judge told me that this was a good reason for his judges to be doing PR bonds, which was kind of a monumental moment in my life. So this data is out there for 12 other counties. I think it was the original 10 they used to validate the CPAT plus 2 more. It might be out there for all the districts, I'm not sure. But in any case, the data's out there, you can access it. There's obviously some variation between counties, but I think overall it's perfectly clear that a greater increase of PR bonds does not equate to a greater risk of failure to appears, at least in any statistical meaningful way, when PR bonds are considered in the context of a risk assessment score. Your experience is pretty close, right?
I think Denver's numbers track these numbers. I can tell you that in Denver, our PR bond rate is up 400%. So 400% compared to last year and the year before. I think it's compared to 2 years ago. So up 400%, which is pretty extraordinary. And in Denver, 50 to 60% of every person, or 50 to 60% of the people that appear at first advisements when bond is being set are being given PR bonds. So half at least, and sometimes higher. I think last month it was 60%. And same thing as in Grand Junction, we're not seeing a large increase in failures to appear. I think the numbers are steady. Oddly enough, the people that we see struggling the most right now are probably the individuals getting out on drug offenses for obvious reasons. They're relapsing when they get out. But if you were to take drug offenses out of the numbers, I think the numbers would be even better. But almost every single person coming into jail on a drug offense right now in Denver is getting a PR bond. Somewhat irrespective of whether they're a CPAT 1, 2, 3, or 4. So you see the 3s and 4s, like I mentioned a moment ago, that are not very successful compared to others. CPAT 1s and 2s are, as you would expect. So I think our numbers are similar to yours, and what you definitely see is when you compare by CPAT category, the ones obviously succeed and come back to court and stay out of trouble almost universally. I mean, the numbers are the same. a little less for CPAD 2, but really good, a little less for CPAD 3, a little less for CPAD 4, and that's what the CPAD was designed to identify, which is people being successful, coming back to court, staying out of trouble. So the argument that we typically make to the judges in our jurisdiction is that if they're a CPAD 1 or 2, you know exactly what they're going to do and how they're going to behave, 9 times, if not 10 times out of 10. And they're successful. You know what the CPAD 3s are going to do. You know what the CPAD 4s are going to do. And that is now data that's been captured over a number of years. So I agree with you that the numbers are pretty indisputable at this point. And the judges can rely on them. And unfortunately, we have a judge in our first advisement court that follows them like a Bible. You know, she's the reason, our judge honestly is the reason that our PR bonds have gone up 400%, because she buys into all the research and all the data that's been collected.
The other thing is, I think once you've done this a little bit, I think the judges, kind of like you're saying, the judges just get it because it's true. It is reality. CPAT 1s don't fail to appear and don't commit new offenses very often. And once the judges have done this for a little while, it becomes very easy. Our bond arguments were to the point now where, you know, on a drug offense, CPAT 1, at our first advisement, the judge doesn't even ask for argument. It's just PR, which is kind of, well, it's not kind of, it's monumental when I think back of what bond arguments used to be like 15 years ago. I mean, it's just mind-blowing to me.
Yeah, and the system we have set up in Denver now is the public defender and the district attorney and pretrial services meet as a group before the cases are ever called up on the docket, and they discuss who's getting a PR bond, a stipulated PR bond. So just because the DA doesn't stipulate in that meeting that somebody's going to get a PR bond doesn't mean the judge is going to automatically set a cash or surety bond. But take a 30-person docket, for example, 15 to 20 people, the DA will just stipulate out of the box that defendants are going to get a PR bond. So most of the time in those meetings, the public defender from my office just sits back and doesn't even say anything, because the district attorney and pretrial services are already just giving out PR bonds based on the pretrial report, the CPAT assessment, and if there's any disagreement, so to speak, between the DA and the PD, it's resolved in court in front of the judge. So we actually do not even have to make very many bond arguments anymore, because we're stipulating up front. That list then goes to the judge. The judge comes out on the bench, and she already knows the people that she's given a PR bond to. So right now, it's the way it works in Denver. Hopefully will spread to other places, because pretrial services has fully bought into what we're doing. The DA, fortunately, has fully bought into what we're doing, and obviously we bought in, 100 years ago to what we're doing. So if you can get your DA and pretrial services, if you have pretrial services to that point, the PD can almost just sit back and watch the judge just grant PR bonds. That's the point that we're at now.
And that probably sounds like nirvana to the defense bar in some places. Some places in Colorado, unfortunately, they are still struggling to get to that point. But the scientific research backs it, practice backs it. You have legit examples where people really comply with bond conditions, especially when they're CPAT 1s and 2s. So once you get them looking at the data, it's hard to argue with. You can't argue with it intelligently. I mentioned how this recidivism angle carried some weight with my DA, at least. And so I particularly like the idea that getting people out of jail keeps them from committing new offenses, because this concept really was a mover in getting your injunction to head down this path of ways. The Arnold Foundation is out there. Their research can be accessed very easily online, but it's just crystal clear the lower risk you are, the higher the chances you will reoffend, the longer you stay in jail. And defense bar people have known this for a million years, because for those of us that do this work, we know you get the kid who's never been in trouble before, he does something dumb, he's in jail, and you know he's in the pod with the guys who, bless their hearts, have perhaps a bit more experience in the criminal justice system. And it's not just housing people, it's a school. And you learn how to do dumb things in a more efficient and perhaps profitable way. So we knew and have known for years and years, get these low-level guys who haven't really been in trouble out of jail. You're not doing them any favors. But courts and DAs obviously didn't see it the same way as we did historically. But now we have science that proves it. That's, I think, one of the funnest things about all this, is the stuff that public defenders have known intuitively for years and years and years has been all validated by the science. And I like being right, and we were. This is sort of a digression, but for what it's worth, when the public defender's office moved into our building in Grand Junction, we had a guy who was grandfathered in on his lease, so he resides in the basement of my building, and he is a short, overweight guy. I'm not fat shaming because I'm overweight. He's a short, overweight guy who wears Western shirts, cowboy boots, and a bolo tie, and short little bald guy. And he has suspenders, and he walks around with his thumb in his suspenders, and he calls me young man. And one day, Wally says to me how he's really on our side, and we need to quit fighting back against these surety bonds. And he said to me, we firmly believe that under the law, everyone is considered innocent until unable to pay us back. Which he thought was funny, and I wanted to cry. But I threw that in there just to let you know, if you're starting this fight, you may have some difficulty with your local bondsman. Wally and I do not exchange Christmas cards, which is sad. So I just wanted to throw some law into this, because we're lawyers and that's what we're supposed to do. I think the important part is the concept that a income-based determination on whether or not people should get out of jail, that's been problematic in the law for a long time. So this idea that wealth should not be the reason you're not sitting in a jail cell is not a new one. What's really new is the scientific research that validates that concept, but certainly the courts were aware of this problem and have been all the way back to Robert Kennedy, but certainly there's case law out there that supports that. These are just a couple of examples I grabbed, but there's a lot more out there going back to the 70s. More recently, there's been a couple of cases that have come out that are right on point with what Chris and I are talking about today, and give you phenomenal legal citations to give to a court to add to the stack of scientific literature you can give to the court. For those of you who don't know about this case, I think this is a 2015 case. If I recall correctly, in Clanton, they had a bond schedule, and this poor person got picked up on shoplifting charges. I was shocked when I went back and looked at this. So one shoplifting charge is 4 shoplifting or 4 ticky-tack charges. So her bond was $2,000 altogether to get out of jail on what should be summonses, not even arrest offenses. The bail bonds people were willing to help her out for 10% because they firmly believe in the presumption of innocence unless you can't pay. And unfortunately, this poor lady didn't have $200, and so it resulted in this lawsuit. Phenomenal opinion in part if you are fighting bail schedules in your jurisdiction. Phenomenal in part because DOJ weighed in and talked about what public defenders and the defense bar have been saying for years and years and years and years. A great opinion to look at if you're fighting with your judges about this. But the best one, in my opinion, is the Harris case out of Texas. This, for those of you who don't know, Harris County includes Houston, and they were locking people up left and right. This case went up to the feds. In the opinion that came out, I think a lot of people have seen it, but if you haven't and you're fighting this fight, you got to read it. Just the amicus briefs on this are phenomenal. Everybody and their brother filed an amicus brief on this, and they lined out the scientific research, they lined out the constitutional arguments, the work that the defense bar collectively did on this case was astonishing. Obviously, you can go look it up on the internet, but if you are starting this kind of fight, you need to have Harris in your back pocket because it is a phenomenal opinion for us, and more importantly, it just lays out, here's your roadmap on how to start this argument with your courts.
Okay, so I'm going to talk about the Colorado bail statutes in particular. So this is the law portion of the training that I got to do.
Because Chris is the smart one.
Right. So there's a lot of words on these slides, and I know our training director's like shooting me daggers right now for all the words on there. But here's the point. The law is definitely our friend in this area, and in Colorado, these laws have been in place now long enough for judges to have figured out what they should be doing. Some judges have got it and changed their practices, others have not. And as defense attorneys, certainly in Colorado, but if you have similar statutes in your jurisdictions, you have to be reminding the judge what the law is and what the language is, because in Colorado, certainly people have been when I say people, I mean judges, because there are people too, right? Some
yes,
of them.
Yes. I know one that I like.
Right. They are ordered by statute to do a mind shift. The historic beliefs about bail and keeping people in jail until their cases have been resolved were thrown out the window with our bail statutes. And they were ordered by statute to have a mind shift on what they think. And like I said, some judges get it and a lot of judges don't. So we have to remind them of what the law says. You can find the Colorado statute, bail statutes in 16.4.101. And then after that, a few basic principles though with the bond statutes. First of all, there's a presumption of release. The judge has to presume that this person should be released and take steps to release that person. Second, the court is instructed that if he or she is to apply restrictions on release, that they need to be least restrictive. And third, courts must individualize all bail decisions. So this is key because historically everybody was treated the same based on what their charge was. And there was a bond schedule, and if you were charged with a class 4 felony offense, you knew what the bond schedule was going to be. That's generally where the judge set it. It was uniform, it was consistent, it was predictable, but it didn't take into account anything other than the charge itself. And the Colorado statute now requires that all judges make individualized decisions, and it can't just be based on what the charge is. There is no more one size fits all. There's no blanket assumptions about the person, the defendant, in front of the court based on the charge itself. They can't make those blanket assumptions. the court is required to look at the individual circumstances, financial circumstances, community circumstances, personal circumstances, family circumstances, work circumstances, whatever it may be. The court is required to do that and make an individualized assessment as to what the bond should be. And the law requires the court to avoid unnecessary pretrial incarceration. And the law further requires that the court must consider a defendant's pretrial risk to reoffend and the defendant's risk to not return. So the court has to judge those two factors: stay out of trouble, return to court. And the preferred practice is to use some type of risk assessment or assessment tool. We use the Colorado pretrial assessment tool, like Steve said. I think there was some hand-wringing early on with the CPAT, whether it was good or bad. Did we like it? Did we not like it? I can tell you, when you look at the numbers and that reflect the results for the different categories, like we were talking about a little while ago, it reflects that the CPAT 1s and 2s do really well. CPAT 3s and 4s not quite as well. So I think there's some validity to the information that's being captured on the CPAT and reported back to the court. And again, I think the numbers bear out that it's in our favor, that it's a tool that is worth trying to use or duplicate, because it's getting a lot of people out of jail. So bail used to be money, right? When you thought about bail, you had to figure out how much money you're going to post. Bail no longer means money. It's not about dollars and cents. And for some reason, the court had an idea that money was its security blanket. If somehow you could scrape together $500 or $1,000 from your friends and family and co-workers and whoever, that somehow that was going to make it more likely that you were going to come back to court and more likely that you were going to stay out of trouble. Again, the research shows that that's not true, that there is no correlation between the two. I can post a $50,000 cash bond and still be a high risk not to return. For our clients, for indigent clients, it didn't matter if the bond was set at $50 or $50 million, you weren't going to get out anyway. So bail now, by statute, and you can see, no longer means money. It is a security which may include a bond with or without monetary conditions. Of note in this definition is the phrase reasonable assurance. So reasonable assurance does not mean 100% certainty. The only way to assure with 100% certainty that a defendant is not going to commit a new offense out on bond or is going to return to court every single time is you put everybody in jail. That's the only way that you can achieve 100% certainty. You can't do that. Nobody's going to do that. It was never that way before. It's not that way now. All the court has to be convinced is that whatever security they are putting in place is that there's a reasonable assurance that this person will come back to court or stay out of trouble. You have to recognize, and the court has to recognize, that everybody has free will. No matter who you let out on bail, everybody has free will. Fortunately, again, for us, the numbers bear out that depending on what category, risk category you are, how you exercise that free will is pretty predictable. But I think a lot of the pushback from the court and from DAs is that, well, we have to be convinced that this person is going to come back and not commit a new crime. Well, there is no 100% guarantee, like I said. The court has to define or decide what is a reasonable risk for this particular person. And that's where the CPAT comes in. This is kind of the summary of conditions, or I guess a summary of considerations. Again, bond schedules, if your court still has a bond schedule, which Denver still has a bond schedule. We actually refer to it as a guideline now. It's only based on the nature of charge. Again, and it's not individualized to the person. So if you have a bond schedule in your jurisdiction, that automatically conflicts with this individualized assessment. So in Denver, we do have guidelines still in place, and In some ways, I think that they're helpful. The guidelines are helpful because, one, it creates expectations, I think, for what the court, I view it as a limitation. I view it as a cap, like it will not go any higher than this. And any good defense attorney that can make a bond argument can come up with reasons why the court should deviate from that cap. Even if you have to dig pretty hard to find good reasons for your client, every defense attorney can come up with reasons to deviate from that cap. So I view it as these guidelines as limitations, but it does create some expectations, I think, for defense counsel, also for our clients, and gives some restrictions, I think, to what the court is able to do. Because I think it's pretty few and far between that the court will go above and beyond the guidelines unless it's an extremely unusual circumstance. Again, I view the cap as kind of a worst case scenario, what the client could get. It's almost like a sentencing range. This is the worst case scenario that I can see the judge doing with regards to bail in your particular case. And I think it encourages, again, some consistency between different courts. Right now in Denver, we have one judge that handles all first advisements. Sometimes she's not there, whether it's she's out on vacation or she has somebody covering her docket that day. And I think it at least gives some consistency between courts that are setting bond. So we can move to the next one. I want to talk about types of bonds, at least in Colorado. The types of bonds in Colorado, first there are unsecured PR bonds. These are bonds that obviously you just get out of jail and there are statutory conditions as part of that bond. So for example, a mandatory protection order. You get a PR bond, but you still have to read through and sign a protection order. Sometimes it precludes people from having contact with others, but more likely than not, it's going to prevent you from picking up any new criminal offense. It's going to prevent you from consuming drugs or alcohol. It may prevent you from having any type of firearm or weapon in your possession. So those are kind of the statutorily mandated conditions that you should be thinking of. There's also unsecured bonds with tailored conditions. So under Colorado, and Steve's going to get to this here shortly, we have a supervision matrix. And as part of our supervision matrix, you look at what the CPAT category is, and then you look at the charge. And based on that, there's a grid that shows what the potential supervision requirements are. Those need to be tailored to the individual, but it kind of gives a framework as to what the court's looking at or should be looking at. So for example, GPS or electronic home monitoring or daily call-ins or sometimes it's monthly call-ins or court check-ins, whatever it may be. It depends on what the matrix shows or recommends. But that is an example of a PR bond with tailored conditions. Then obviously we have secured monetary bonds, which are pretty traditional that people know about. And then we have bonds with real estate conditions, which are what people think of as the property bonds. One thing to keep in mind in Colorado under our statute, the court can only forfeit a bond for failure to appear. The court cannot forfeit a bond for violating a condition. So you can go out and miss your curfew or violate your GPS or consume drugs or alcohol. The court can revoke your bond or raise your bond, but the court can't forfeit your bond. The court can only forfeit your bond in Colorado if you have failed to appear. The court in Colorado, when trying to determine what the conditions are in setting the bond, the court is required to conduct a hearing upon request, seeking relief from a condition. So if the court imposes a condition on your client, before the court can do that, your client is entitled to a hearing in front of the judge. It says upon request or upon motion. I don't think that needs to be a written motion. We don't do written motions in our court. Frankly, there's too many. Like I said, if we have 30 people on the docket, you're not going to file a written motion regarding those conditions. But the court is required to conduct a hearing when seeking to set conditions. The court decides what conditions to impose, keeping in mind that the conditions that are set have to somehow affect the person, have some type of impact on the person's ability to stay out of trouble or return to court. That's what the conditions need to be focused on, those two principles. Again, there's some tension with the matrix because the matrix is, in a lot of jurisdictions, even in Denver, the court thinks that they're automatic conditions, like they have to impose these conditions, which they don't. The court doesn't have to impose any tailored condition if the court doesn't want to. So there's this tension a little bit between the court setting conditions and what the matrix requires them to do. The matrix doesn't require the court to do anything. It's really, again, a guideline. A court cannot order a defendant to enter treatment as a condition of bond, can't order it. The court can order monitoring and testing, but the court can't order actual treatment. However, I think the work around that from the court's perspective is they're asking the defendant to consent to treatment, and they're using that consent or lack of consent as a individualized factor in deciding what bond to set and what conditions to impose. Just a few more things. I think we've already had the slide on pretrial services. There we go.
Sorry about that.
With regards to pretrial services, I understand some jurisdictions and some people are lukewarm to pretrial services. Not every jurisdiction has a pretrial services program. I know in Denver we have one. It's very big, and they've been a really good partner with us in getting people out of jail. They were also a really good partner with us when we were developing our matrix of telling the court the people that don't need to have pretrial services. Because I think a lot of judges, the default position is, I'm going to let you out on bond, but I'm going to impose pretrial services every single time on every single case. And at least in Denver with our pretrial program, they were the ones advocating to the court that not everybody needs pretrial services. We need to focus our efforts on the category 3 and 4 people that get out, sometimes the 2s, but generally the category 1s and the category 2s don't need to have pretrial supervision. If you have a client where bond is set, a monetary bond is set, and your client in Colorado is not able to post that bond for whatever reason, by statute 164107, your client is entitled to have a hearing after 7 days from when the bond was set. So not after 7 days from when he was arrested. After the court sets the bond, if your client then is in custody for at least 7 days, the statute allows your court or allows your client to request a hearing in front of the court, and the court has to hear that. Now, it doesn't mean that the court has to have a hearing, I guess, in court with both sides arguing for or against. There can be a summary denial of that request, but the court is at least instructed to address that request. The kicker on this is you must include additional evidence that the court did not hear at the initial bond setting. And again, as defense attorneys, we can come up with a reason. We can come up with something that the court did not hear at that original bond setting in order to get this reheard. But again, the court shall conduct a hearing. That hearing shall be held within 14 days. If you don't have any new information to provide, the court can summarily deny it. And in Denver, there has been a practice where if somebody is in custody and hasn't posted a bond after 7 days, 14 days, whatever it may be, our pretrial services will go out and contact that person and ask why. Now, if it's somebody with a parole hold or, it's a VRA case with, an F2 where the bond is set fairly high, they're likely not going to contact that person. But if it's somebody with a CPAD 1 or 2, sometimes even a 3 with a fairly low bond, our pretrial services will contact that person and inquire why. So we can, as defense counsel, file a motion and request that the court reconsider that. The last slide I think we have regarding the law is on misdemeanor cases. 16.4.113 is the statute that pertains to this, but the gist is that a PR bond is required for any Class 3 felony offense, any petty offense in Colorado, or any offense in which the potential punishment is 6 months or less, which is generally a Class 3 misdemeanor. There's exceptions. Those exceptions are listed in the statute and also listed on this slide. But the presumption or the automatic for the court is if you're charged with M3 petty or something that has no more than 6 months punishment, you should be getting a PR bond automatically. So that's it on the law.
So we keep talking about the CPAT. People in Colorado are familiar with this, but for those who haven't, we thought we would throw it up there for you. Depending upon the jurisdiction, even in Colorado, the CPAT's done by various people. Some of our rural jurisdictions, we have the public defenders out there doing the CPAT. Other jurisdictions have a pretrial services program doing them. But the CPAT's not that complicated. And, even I can fill out a CPAT on somebody. It's just ask the questions, score it up, and you will get your total score. And we already know which scores put you in which risk category. So that's what the CPAT looks like right there. I'm going to show you some stuff from Grand Junction specifically. And honestly, part of the reason is I've spent a lot of years in committee meetings with judges and DAs and sheriffs, and because of that, I feel entitled to brag slightly, pardon me. This is what in Grand Junction we get on every single person who's arrested. We have spent so much time fighting over how this chart looks. But the CPAT is done by pretrial services when somebody's first placed into custody. You can see on the left-hand side toward the top, once you have the CPAT score, they plug it into the top right under current charges. We have the risk of new offenses and failure to appears typed in right next to the category so that the judges don't forget, and every single person gets one of these when we go into argue bond. It makes, in Grand Junction, just like in Denver, when we see those Cat 1s, it takes almost, usually, no work to get a PR bond because all this stuff is laid out for folks. This is our guidelines. Chris talked about the Denver guidelines. This is an example of what the guidelines look in Mesa County. As you can see, it's set out with the different categories to the side, and then it's a matrix based upon the type of offense, and it sets out what the expectation is for bond. I love the idea that this is a cap. Sometimes my judges treat it as a suggestion, but we are pushing them hard to follow the guideline that we've spent so many hours in committee meetings talking about, and it's made a huge difference, obviously.
And I would say on ours, when we were trying to get our judges to buy into the matrix, our pretrial services officers, and in particular the head of pretrial services, would go over and meet with the judge individually on certain cases after the fact and say, this person should be administrative supervision. Based on the matrix, you're over supervising this person. What's going on? And it was basically a check from our pretrial services to the court to say, you're not doing what we've all agreed the judges should be doing. And that, took about, 2-3 weeks for our pretrial services to do that before the judge finally figured out, okay, I'll just do what they ask us to do. Because the message was there was a lot of people that spent a lot of time working on these matrix, I don't know what the plural is of that, on the matrix, and you're not following it. And so we're not just gonna, dump this out at the judge's bench just because you don't like it. You need to follow it. And our pretrial service is the one that kind of carried the water on that.
So getting to the point where you have a matrix like this one, or like Denver has, for those of you who are starting this fight or early in the fight, getting to this point takes a lot of work and a lot of talking to people of interest perhaps to no one but me. I spent 2 hours in 2 different meetings arguing with DAs and judges about whether or not the colors should be green and red or mauve and pink or something, I don't know. So it takes a lot of time, it takes a lot of communication. It can be very frustrating, but as we showed you earlier, the outcome is human beings are getting out of cages. In the 21st Judicial District, our DA's hot button, understandably, is domestic violence, and so we specifically included the DVSI, and the DVSI is another validated risk assessment, which actually looks like that. And so our matrix has a specific difference for the DVSI score. Do you guys do that too?
We do. The way it works for us is you get your score on that is a enhancer, so to speak. So if you fall in a particular box, and it's supposed to be yellow supervision, but we use the ODARA. If your ODARA score is within a certain range, it's an enhancer, which will kick you up to the next level.
So I guess that's an example of, depending upon your audience, depending upon your particular DA, depending upon your particular judge, you need to figure out what their hot buttons are, and those are the areas where you can negotiate, get some consensus, but the bottom line boils down to what we started with. Cash bonds don't increase the chances that people are going to show up. Risk score tells you everything you need to know. Once you buy into that, the rest of this is not unimportant, but frankly, you can get a lot of movement by negotiating whether or not you're going to use the DVSI or you're going to use some other risk assessment, that kind of stuff. So I was just going to end on this note, Chris, if you want to chime in, but it takes a lot of time, it takes a lot of committee meetings, which is my favorite thing in the world, but you can make really, really wonderful changes. I know that in some places, they're just starting this process, and hopefully what we've talked about gives you some idea of where you can get to. Other places are a lot farther along. Denver, for example, it's always a fight. I don't get to not go to committee meetings anymore because now we're fighting about things like what are the consequences for pretrial services violations and that kind of stuff. So the fight never ends, but the progress is real. We've gotten human beings out of cages in Mace County. We've gotten them out of custody in Denver. We're getting them out of custody all over the state of Colorado. So I'd rather be fighting about what we do with a hot UA guy who was out on bond, and that's where we've got to.
Yeah, and I would just say that it is a continuous struggle, and you have to figure out who your allies are, and a lot of times they're not the people you would normally think they are. I can tell you in Denver, the sheriff's department was a great partner because this directly impacts them. Mm-hmm. When their jails are full or near capacity, they're the first people that want to let to reduce it. So sheriff's department was a great ally for us. Pretrial services, like I said, was a good ally for us. But if you can get people like that on your side, everybody else tends to come along, and then once the momentum is shifted in your direction, it continues. Nobody wants to backslide. So find out who your allies are and think of people other than your normal group that you would expect to support you.
The sheriff in our jurisdiction also was an ally, which was a psychological disconnect for me. But boy, they love the money savings. So that's a great way to build some unexpected allies. So,
Yep.
thank you for your time.
Thank you.